Good morning, family. How are you guys doing? This is Martise Brumfield with Martise Brumfield Real Estate, and I am here with Kanumi Maatafali. Got that right this time.
You did. Good morning.
Good morning, good morning. And so this morning we wanted to share with you some important tips that you can use. As you know, right now our country is in a state of, in this pandemic right now with our health crisis. And we thought it would be a good idea for us to share some practical information with you that you can maybe implement into your estate planning. Unfortunately, there have been a number of individuals who have passed away as a result of COVID-19, the coronavirus. In fact, it's currently being reported that we had recently, as of April 21st, 44,000 deaths in the United States alone. So we know this information is very critical for us to not only know about it, but get the word out about what you can do to plan, prepare for your death and demise whenever that happens. You know, it's not necessarily always a great topic to discuss. I know, Kanumi deals with this all the time, but nonetheless, it's a conversation that we have to have. And as you guys can see here, we're in our conference room, but we're practicing social distancing as much as we possibly can, so then that way we can protect one another. So definitely use this opportunity to if you have any specific questions that you guys would like to have answered, be sure to comment in the comment box. But we definitely want you guys to share, like, and engage, and definitely tag someone who you think might need this information. So, Kanumi, let's get started.
Let's get started. We're just waiting on.
Yeah. So first things first. Just kind of briefly explain the difference between a living trust and a will.
The difference between a living trust and a will. With a will, basically, both allow you to sort of tell other people what you would like to do with your assets. You give them a list of what your assets are. You can tell people in both a will or a living trust who you would like your assets to go to. Right now, you're in control of that.
Okay.
And in being in control of that, you determine and you dictate where it's going. With a will, though, although you tell somebody, hey, this is what I want to do with my stuff, because your stuff is still in your name and not in the name of your will or any specific individual, the individual who you leave in charge of your will to distribute your assets still have to go to court to file court papers to tell the court, I've been named the administrator of the estate, and based on being named in the will as the administrator of the estate, I am obligated to pass on the assets as the person has indicated. But you still have to go to court in order to have the court give you some order, which are called letters, to be able to distribute, take the stuff out of an individual's name, put it in the name of the estate, and then distribute it to the individuals as dictated by the person who did the will. A living trust does the opposite. A living trust still allows you to name what all your assets, distribute them to different individuals as you would like, but it allows you to appoint a trustee to overlook your assets. With the living trust, what you end up doing is you take the assets and literally put them into the name of your trust. So let's say I had a trust called the Kanumi. So every document, whether it's my grant deed, whether it's my bank accounts, insurance, any asset, stocks and bonds, any asset, then I will go and I will change the name of those assets, the name on the assets in the name of Kanumi Matafali's living trust. So now when I pass away, anybody can then go show what they call, it's called a declaration of trust. Anybody can take that declaration of trust, give it to whoever it is, if it's with the bank, you take it to the bank, they'll honor that. If you put your property in the name of your trust, basically you'll do an affidavit of death showing that, again, I am the trustee of, or let's back up some. I have to appoint someone the trustee of my estate when I pass. So let's assume I make Martise my trustee. So when I pass away, now you go to the bank, you go to the recorder's office where the deeds are, and you start getting all those assets pulled into the name of, into a bank account that's in the name of the trust.
Okay.
You don't have to go to court. You don't have to do anything in order to get those assets into the name of the trust.
Okay.
And now you then distribute all of those assets as I wished. If I want them to go to my kids, if I want them to go to my cat cemetery, sanctuary, whatever it is I want it to go, that document, this is my wishes for my assets.
Okay.
So that's the difference between a will and a living trust. Will, you got to go to court. Trust, whoever the trustee is, then can just go collect all the assets.
Okay. Now, a question that I have, because I know many of our viewers are probably going to ask the same question then too, is there one that you prefer over the other one? I know when I'm talking with clients and I ask them about their estate planning, if they have something already put together, such as a will or a living trust, many say that they have a will. So is one more preferred versus the other one?
Yes, because again, what happens is, let's assume with the market the way it is now, let's assume you own $1 million piece of property, right?
Okay.
And with the will, I have to go to court in order to administer my will, the wishes in my will. So again, let's say you're the administrator in my will. Now you have to take that document, file all the paperwork. So here's the cost. The filing fee right now is $435.
Okay.
The cost for, you got to put it in a newspaper for 30 days.
Okay.
So that's $200 and some odd dollars.
All right.
And then there are a few other costs, mailing, all of that other stuff. So you can figure the cost, I always tell people, $800 and $1,300, depending on what you have to do with the cost.
Okay.
Now, you could do the paperwork yourself to go into court.
Okay.
Right? So that'll save you a little money, but let's assume you hire an attorney to do that.
Okay.
All fees for probate are statutory.
Okay.
So the first, I believe, $200,000 is 4%. The next two, it may be more than this. I'm just reciting off the top of my head.
Okay.
But it goes 4, then 3, then 2, then 1%. So let's say on $1 million estate, the attorney just statutorily, he may have done nothing but file your paperwork.
Okay.
He will be entitled to it statutorily about $10,000 to $13,000.
Off the top?
Off the top.
Wow, okay.
So with a will, you're basically about to spend about $13,000, $14,000, right?
Yeah.
In order to get that will administered through the courts.
Okay.
Because at the end of the day, once you get all the assets into the will, into a bank account, he's still the attorney, or you, whoever does it, still has to close the estate with the court.
Yes, okay.
So that's what they call a final accounting. You have to do all of that with the court. So,
and this, of course, just for you guys that are listening, this is for you who, we're talking about property that ends up having to go to probate.
Yes.
Okay.
And that's in a will. So
and that's
whether you have a will, whether you have a will or you don't have a will, it's going into probate court.
Oh, really?
Yes.
So even if you have a will, it's still going into probate court?
Because all the assets are still in my name.
Oh, got it. Okay.
So because all the assets are still in my name, all the will does is tell the court, this is how I want it distributed. That's all.
Okay.
But no one, even you as my administrator, can go into anywhere and say, I'm the administrator of the estate. Now, in the bank, the recorder's office, all of them are telling.
Okay. So I know we have a different generation of people that are watching this right now who swear by, oh, I have a will, I have a will, I have a will, I'm protected. In times past, that was the go-to thing, to have a will. So now it's the complete opposite. You have to have a living trust.
Well, again, all the will does is tell people, this is how I want my stuff distributed. Okay. So nobody can then, as long as 3, 4, 5 people have a copy of your will, right? But I left you as my administrator. You can't then say, I'm going to put all that stuff in my, because the will is telling the court, this is how I want it distributed.
Got it.
So when you do your final accounting, if your final accounting is not what the will says, then I got to back up a little bit. This is why the court then tells you to go get insurance.
Okay.
Right? They tell you to go get bonded, go get a bond, because if my estate is worth $1 million, I leave you as the administrator, and then you go somehow are able to pull all of that property, put it in your name, right?
Yeah.
So the court says, no, you got to go get a bond.
Okay.
So if you mess up my estate that's supposed to go to all the other people who I named, we just go after the bond.
Okay.
And they always get a bond for the value of the estate.
Got it.
So that's why I say whether it's a will or you die intestate without one, it's the same process.
Okay. So it really is better, especially in this day and age, to have a living trust.
It's better to have a living trust because then again, you're saving yourself money.
Yes.
To an extent, you're saving yourself a lot of money when trying to distribute your estate to the people who you want to give it to.
Okay.
And again, I say normally because again, sometimes even when you leave a living trust and you leave someone who you thought would distribute the assets appropriately
upon your wishes.
Yeah. Sometimes those people don't do what you wish.
Yes. They don't. They have a mind of their own.
And now the other people who are involved, who are beneficiaries of your living trust, have a document that they can then go into court again and say, hey,
okay.
So as long as the people are following the living trust, you're correct. It's easier that way.
It's easier that way.
But if not, then like I say, the beneficiaries who are in the trust, who are supposed to get part of the estate, then have a recourse to run into court. So that's normally what happens. Normally, I think the majority of the time, if you have a living trust, people do what they say they're going, what you want them to do. Because you're putting the person in charge who you trust will do the right things for others.
For others. Absolutely. So it's important who you name.
Yes,
okay.
Very much so.
So then my next question becomes, and I did get a question from someone, but before I get to his question, and where, because again, with this whole COVID-19 and coronavirus issue, how and where does the health directive come into play? Because as we know, people got sick. With, I'm sure, with the uncertainty of, okay, well, I'm getting sick, but I'm not going to die from this.
Right.
So of course, there were a number of people that were, I hate to say it, but were unprepared, for their demise. So where does the health directive come into play when it comes to the living trust or the will, and how does all that work?
Well, again, the health directive, more so, again, you're nominating someone who in your living trust, you can say, if I'm in the hospital, number one, this person then can do all of my affairs as it relates to anything that needs to be signed in the hospital. That person can be different from the person who's the trustee over your assets. It can be the same person, but it can be different.
Okay.
So like I say, okay, I trust you to do all my stuff regarding my assets. Healthcare Directive.
Okay.
So, although I trust you as my friend to make sure everybody else, even my wife, gets their share, I trust my wife to be there by my side and do everything else I need to do.
Okay.
Right? Now, I can make that person one and the same for everything in the trust, or I can separate it from my healthcare directive. So the healthcare directive is really just telling the hospital, let's say, for example, if I'm on life support, right? The person who you have as your primary trustee for your healthcare directive, that person in the hospital will go to, well, you have the decision making whether we should pull the plug or not. Right? So now the family members are not in there arguing, don't pull the plug, pull the plug, don't pull the plug, pull the plug.
Yeah.
Right? So you got one person who makes that decision about pulling the plug.
Wow. Okay.
Or you become infirm. You're alive, you're in a right? But you're alive.
Right.
That person can say, no, let's do everything that's life-sustaining to keep her alive maybe one day, because it has happened. People have come out of comas. Right? So that's the person who you're leaving in charge of those things. And then again, when you pass away, ultimately, that person is the one that comes in, they'll tell them what to do with your remains, and then they direct the hospital and set up all the funeral arrangements. But again, you're leaving one person in charge. Now, you can have co-trustees for everything. You can have two people making those decisions. Again, if you believe two people can get along to make those decisions. So there's a lot you can do with that. But the healthcare directive is really one of those things that has more to do when I'm in the hospital, I'm infirm, I'm incapable of making those hospital decisions. I leave someone else in charge to make those.
Okay. So then that actually does bring up my next question, because I had a gentleman that his question specifically was, he had a living trust prepared 20 years ago. But over the years, things have changed. He's been writing in what his new wishes are in the living trust. Is that a still valid living trust, or do you recommend him going and now getting that official? Or is his signature and his write-in on the living trust good enough?
Depends on how he's done it. If he's made the necessary changes, wrote them in, signed them, initialed them, everybody can say, those were his wishes, then you're fine. As long as he has the assets in the name of the trust.
Okay.
What he wanted to do with them, he wrote out. Right?
Right.
Now, if he acquired new assets but didn't put those into the name of the trust, then those new assets may have to go through probate.
Got it. Okay.
Because those assets weren't there when he first wrote that trust 20 years ago.
Okay.
Now, if he wrote the 20 years ago and then he added them to his trust, but he didn't change the title
on the item.
Yes.
Okay.
Now, there's some people who can go into court and say, hey, I want the court to change the deed at the recorder's office into the name of the living trust because those were his wishes.
Okay.
It's a lot easier if you have a trust that's 20 years old that you're trying to make changes to just do an amendment to the living trust or just do another living trust, cancel the old one, do a new one that incorporates everything. Yes.
Okay. Okay. And let me check here and see if we have any questions from our viewers here. She says, this is from Michelle. She says, I have a living trust. If I pass away on a living trust, can the living trust be contested?
They could be contested, but most of the time the contesting is whether or not you signed the document, whether or not...
That's a good question too. Thanks, Michelle.
Yes. Whether or not the document itself, most people contest it because they're saying when she did it, she was, had Alzheimer's. That's not her signature.
Okay.
But for the most part, as long as it's in there, most people don't contest it. And I'm pretty sure if you have a no contest clause in there, that if someone does contest it, then they get nothing. That stops people from wanting it in the court.
Yeah, that's true. That's true, because if they want to fight it, they can.
Yes. So as long as, when you did the trust wasn't done when you were in an incapacitated state or state of mind, most of the time people don't run in there and do that.
Okay. Let's see if we have any additional questions. I see a few people that have joined in on our conversation. Let's see here. Brandy, did you have any questions? I know I do particularly have a question because I know right now with the younger generation too, and of course, or just with people in general who may not necessarily be homeowners right now, but they are, may live in an apartment or may just simply be renting. Do you recommend still having a living trust or a will in place? Should they not be someone who owns property per se?
Well, and I have to get the provision. I think the provision is that you have personal assets that are less than $150,000. No one has to run in court.
Okay.
It's called an affidavit of an estate less than $150,000.
Okay.
If the estate is less than $150,000, most people will accept as a form that you fill out. You don't have to file it with the court. You take that form, you give it to the bank. Normally it's the bank because in your scenario, the person doesn't own real estate.
They don't own real estate, yeah.
So
but if they own anything else that maybe, let's say they own something that's like an antique car that's a collector's item of some sort.
As long as the total amount of those assets are less than $150,000.
They don't need a will.
They don't need a will.
Okay.
They don't need to run into court.
They don't need a will or trust.
But then again, you dictate as to who it goes to.
Okay.
But if you don't have either one of those, you die intestate. Now it just goes to your heirs. So the first heirs to start off with your children. If you have no children, or you have children, they passed away and they had children, then it goes to that lineage. If you had no children and no descendants of any of those children, then it starts up with your parents.
Okay.
And then if your parents pass, then it goes down to your siblings. And then if no siblings, then it's spread. They cover the gambit of actually when you die intestate as to who it goes to.
Okay.
So a will basically says this is who I want it to go to specifically. A trust basically says you don't have to run into court and get that done. And then, like I said, if you die intestate, the state already says who gets what.
Okay, that makes sense. I think that was pretty much it. Oh, you did go over the cost, because that was one of the questions that I did have. What is the expected cost of doing it yourself? And you shared it was about what?
About $30. It's just the cost, unless you get a fee waiver. Most of it is just the cost of filing, putting it in the newspaper, mailing, and then you have to do a final accounting, and they charge for that.
Okay.
$200 and some dollars, somewhere in there. So I always say the cost normally goes somewhere between $800 to $1,300 total if you're doing it yourself.
If you're doing it yourself.
Yes.
Are you comfortable with quoting your fee if someone, if someone in our audience is actually considering or needs to put together, a living trust? Are you comfortable with giving you and sharing your fees with what you charge?
Well, what I do is I charge a basic fee of about $1,200. And what that does is I don't give you all the bells and whistles. I don't put it in a binder because a living trust is just paper. It's not the binder. It's not all the pretty stuff. So I'm going to charge you a lot less than somebody would do to say, hey, I put it in a binder, charge you $2,500 or $100.
Exactly.
And all they really did was put it in a binder with your name on it.
Okay.
Right?
Right.
But if you like that, I can charge you $2,500 and put it in a binder.
I think these days we want to be money smart.
And so what I do is I just prepare the documentation, get your information, prepare the documentation, send what you actually need. You get it notarized. Once you get it notarized, I say give it to about 2 or 3 people.
Okay.
So, because most people, you say, oh, take it and put it in your safe deposit box. And most people don't know you got a safe deposit box. Or you take it, you put it in somewhere in one of your documents, but you move 5 or 6 times.
Yeah.
Now the document is lost.
Yes.
Right? Or nowadays you just take it, scan it, put it in one of the folders, and hold on to it. Okay. But I always say make sure 2 or 3 people who you trust have that.
Have at least a copy of it.
Yes.
Okay. All right. I think that's it. Let me see if I have any additional questions that came in. Okay, Michelle has another question. She says, where would my loved ones take the living trust? It says the court. Are there any fees that my loved ones would be responsible for?
No. Whoever you left as the trustee basically should have a copy of that trust. Okay. Or the trustee and the successor trustee. You should name at least 2 or 3 people. So if the first one passes away, the second person is the trustee. If the second person passes away, the third person is the trustee. And those people should have a copy of it. They don't have to do anything but have that declaration of trust. Mm-hmm. And with that document, they can go to all the places in order to take those assets. Now, if you're giving it to them personally, they can do what they need to with it. Mm-hmm. They go sell it, proceeds go to them. But if you have 2 or 3 heirs that it's going to go to, they're supposed to take those assets, put it in a trust account with your name and the name of the estate of, and then all the monies is dumped into that account, and then that person is supposed to distribute it to the heirs as the trust says. As long as all of that happens, nobody needs to go to court, nobody needs to do anything.
Good. I think that was all the questions that we have. Thank you, Michelle, for giving us some questions and something to think about. Kanumi, for those of our audience members who would like to get in contact with you specifically, please share your information.
All right, my phone number is 323-595-1200. Again, that's 323-595-1200. You can reach me by email at K as in Kevin, M as in Mary, T as in Tom, dot or period, A as in Apple, M as in Mary, P as in Paul, A as in Apple, H as in Harry, at Excite, that's EXCITE.com.
Perfect. Thank you.
Okay.
And again, for those of you who need to get in contact, we will provide his information in the comment section right after this particular broadcast. We want to thank you guys for joining us. And be sure to follow us on our platforms at Martise Brumfield Real Estate on Facebook, Instagram, as well as LinkedIn. And most importantly, we do have a YouTube channel. So for those of you who have information or would like more information about home improvements, loan approvals, things of that nature, definitely check out our videos on our YouTube channel. Kanumi, that's it.
That's it. Well, thank you.
Thank you guys, and we'll talk to you soon. Stay tuned for our next broadcast as we will be discussing part 2 of the mortgage industry. So stay tuned. We'll be coming live again real shortly. Take care, you guys. Bye-bye.